Right out of the gate, this case picks up where the last one left off, and the energy is already tense. We're watching a familiar sovereign citizen pattern unfold. Confidence built on online legal theories meeting a real courtroom run by real rules. Instead of addressing the actual charges, the defendant immediately pivots to jurisdiction and identity arguments. That's the tell. These hearings usually start with questions, then turn into confrontations. And when that happens, patience wears thin fast. Buckle up, because this isn't just about traffic violations anymore.
So, I am Jamil of the Family Law Court. The motions that I filed and the documents that I have filed have all been trying to ascertain the jurisdiction of this court. And I don't understand the nature and cause of the action against me. And I'm trying to understand under what jurisdiction the court intends to proceed. First of all, is this going to be a civil or a criminal action? Criminal. Okay. Your Honor, the Constitution grants this court two criminal jurisdictions. One is criminal jurisdiction under the common law, and one is a criminal jurisdiction under admiralty or military tribunal. From Article 1, Section 8, Clause 17 of the Constitution.
Here's where the strategy becomes clear. The defendant isn't trying to resolve the case. He's trying to force the court into a philosophical debate. Sovereign-style arguments almost always center on jurisdiction, hoping that confusion equals dismissal. But courts don't operate on personal interpretations of constitutional clauses. They operate on state statutes and court rules. Notice how the judge keeps steering things back to procedure while he keeps circling the same question. This disconnect is exactly why these encounters spiral. One side is moving forward, the other is stuck on theory.
So in which of these two criminal jurisdictions does the court intend to try?
Where is your motion, sir?
There's a motion filed there. It's a motion to dismiss based on lack of subject matter jurisdiction.
All right, I'm going to deny that motion. I'm going to set a bench trial or jury trial if you choose. Which one would you want to have?
Okay, Your Honor, under what grounds, what facts and findings, conclusions of law are you denying that motion to dismiss? I'm trying to understand the jurisdiction of the court. You have not disclosed it to me. I'm asking you
about. To disclose it to you. Check the court rules, sir.
Well, Your Honor, the Sixth Amendment grants me the right to understand the nature and cause of any action brought against me, and it grants you the duty to inform me. So I don't think you would be breaching your oath of office if you were to inform me under which jurisdiction this court intends to proceed. In order for me to intelligently defend myself without an attorney, I need to understand which jurisdiction the court intends to proceed to conduct a defense.
You have a very good attorney on the line, Mr. Elwood's area. If you want to speak to him in a breakout room, I can give you that opportunity. Other than that, I'm going to set a bench trial or a jury trial in the matter.
Okay. Please let the record show that I have attempted to understand or to ask what is the jurisdiction of the court is operating under. And it appears that the court is operating under a secret jurisdiction. Maybe only known to bar members and licensed attorneys. So let the record show that I am trying to understand jurisdiction and nature of cause against me, and the court has denied me that information.
I'm not denying you the information. The information is public information, sir. The information is outlined in the Michigan court rules. You need to read the Michigan court rules, and you can find out jurisdiction. It'll tell you everything about jurisdiction. That's entirely public information. You can go online and type in the court rules. The whole book is ascertainable to you online.
Sir, the Sixth Amendment grants
I'm
you
not required
to inform me of the nature and cause of any action brought against me. And right now, you are denying that right.
Sir, don't speak over me. You want me to inform you of the nature and cause of the action. You're charged with driving drive while license not valid or improper. The other charges, no insurance, misdemeanor. The allegation is that you were driving the same 2011 Jaguar in the city of Detroit without the proper registration on that.
When the motion gets denied, that's a major turning point. This is the moment where most defendants either adapt or double down. Instead of shifting gears, he presses harder, demanding legal justifications in real time. But that's not how motions work. Judges rule based on filings and established law, not live debates. The offer of a bench or jury trial shows the system doing what it always does, providing process. Whether he accepts that process or not doesn't stop it from moving forward.
Okay, good. I'm sorry.
Those are the charges. Do you want a bench trial or a jury trial?
Your Honor, I am trying to understand the jurisdiction of this court. As I said, you told me it was a criminal jurisdiction.
If you read the Michigan court rules, the Michigan court rules will tell you and give you jurisdiction. So they have a copy of the Michigan court rules online or at the public library. I'm sure it is not as easily ascertainable, and we're not going to keep going down this road, young man. Do you want a bench trial?
So I cannot. I'm asking you a very specific question, and it is this a criminal jurisdiction under common law, or is it a criminal jurisdiction under military tribunal?
Listen, it's let's move on to the next person.
Sir, please answer that.
It
can only be one or the other.
You'll leave me no choice but to hold you in contempt. I'm asking you a specific question. You're just.
I do not wish to be held in contempt. I am trying to exercise my Sixth Amendment right. I can show you Constitution. Exercise of a constitutional right cannot be converted into a crime.
Now the court lays everything out plainly. Multiple driving-related violations, each carrying real consequences. This is the practical heart of the case. No abstractions, just alleged conduct and statutory offenses. And yet, instead of responding to that reality, the defendant pivots right back to jurisdiction and constitutional language. This is a classic sovereign move. Avoid the substance by attacking the framework. But understanding the charges doesn't require agreement with them. It simply means acknowledging what you're facing, something he repeatedly resists.
Okay, if you have a motion that I've already denied one of your motions, if you have another motion,
under what basis? Under what grounds have you denied my motions?
It's not my job to explain to you all of the court rules, sir.
So there's only two jurisdictions which this court can operate under.
You're going to be treated just like any other lawyer that comes in this courtroom. So you have to know the rules.
Yeah, so I'm not trying to seek legal advice or ask you what the rules are. I'm asking you a very specific question. There can only be two jurisdictions under criminal law. And is it under common law or is it
At this point, frustration starts to surface on both sides. The judge is trying to manage a docket. The defendant is trying to control the conversation. Interruptions increase, warnings follow, and the tone sharpens. This is where courtroom decorum becomes critical. Judges expect motions to be filed, not argued endlessly. Every time he talks over the court, he weakens his own position. What could be handled through paperwork and hearings is turning into a power struggle, and that never ends well for the person without the gavel.
On the record for Mr. Jamil Lockhart.
Yes.
All right. This is the last time I'm going to say this. I'm not going to continue to go back and forth with you regarding court rules and all of those positions that you have. If you put it in a motion, we'll set a motion hearing date.
If you are setting a motion hearing date, you are doing so without my understanding of the nature and cause of the action against me.
Listen,
I cannot move forward until I have these questions answered. These are basic questions that you are obligated under the Sixth Amendment.
I'm not obligated to answer any of that stuff. I told you, I gave you the answer to that stuff by looking in the court rules. You're obligated to know the rules.
Sir, what you mentioned is statutory law. And if we are proceeding under some kind of statutory law, I motion that we dismiss for lack of a sworn complaint or anything signed by injured party. And in fact, where is the injured party? Is the officer present, and who is the injured party in this case?
The officer is not required to be present today. It is a pretrial date. I'll hold that dismissal motion in abeyance until the date of trial. If the date of trial, if there's no signed complaint on the date of trial, then we will dismiss by no signed complaint. So I'll give the city an opportunity to come up with a signed complaint.
I'm sorry, is the city the injured party here?
Yeah, you're here.
Okay, well, sir, I move that we either dismiss this case or move this case to federal court. If the city is the plaintiff or injured party, they cannot also be the judge and prosecutor.
File a motion on that, sir. If you're saying that I do have a signed complaint.
Well, that brings me back to my original question. Is this a statutory proceeding? Because if there is, there would have to be an international contract or agreement. And I would implore the prosecution to put that agreement on the record and explain how I am party to it.
Young man, you got to go do your homework, okay? And it appears that you're taking this position and you're adamant about this position, and you're free to do that. Now, whether you're going to win at this position, that's going to be up to what you say in your brief. And how it relates to the law, and we'll make a decision on that stuff, okay? But at this point, you need to educate yourself, because you seem like a very articulate, educated young man. You need to educate yourself on court rules and procedure. Until you get it correct, we can't talk, because we have to be speaking the same language. Okay.
I mean, that's the main thing I'm trying to understand here, sir. Is this a common law criminal procedure
I'm giving you some direction on.
Well, sir, I don't know which rules. If you could tell me where I could find the rules for.
I told you, go to Michigan court rules. They got Michigan court rules.
They have rules for criminal procedure under statutory law.
Yes, very much so.
Could you please?
This section perfectly exposes the gap between internet law and actual law. Ideas about contracts, injured parties, and admiralty jurisdiction sound impressive online, but they collapse under scrutiny in real court. You don't opt out of traffic laws by refusing consent, and you don't nullify charges by demanding international agreements. The judge repeatedly explains where the rules live and how to challenge them properly. Through written motions. That's the system offering a door, but he keeps trying to climb through the window.
He directed you to it. Michigan court rules. There's a book that's over 1,000 pages, and it'll answer, well, close to 1,000 pages. It has those questions outlined in there. You're expected to know
Are
that.
those Michigan court rules? Is that statutory law?
I'm not going to keep going back and forth with you. So whatever motions that you have, that's how you speak to the court, through motions. And whatever motions that you have, I will review it. I read all the motions that come across. I check all the law myself. And if you have some law, I would suggest that law that you're saying that we don't.
Your Honor, there is no international contract. I mean, we've asked the prosecutor to produce an international contract that would bind me to this statutory proceeding. And I'm not aware of any contract. In the absence of such contract.
Here comes the critical warning. When a judge mentions the possibility of a warrant, that's not rhetoric, that's consequence. Courts need compliance with scheduling, appearances, and procedure. If someone signals they won't participate, the court has tools to enforce attendance. Instead of de-escalating, the defendant continues pressing the same arguments, pushing the situation closer to enforcement. This is the danger zone of sovereign behavior, mistaking persistence for leverage. At this stage, every extra word risks turning paperwork problems into custody problems.
And for the record, I would just
in order to You can move to the circuit court, and you can appeal my decision as it relates to that. But we're not going to keep on going back and forth.
I think we should move this case to federal court. As I stated, if the city is the inter-party,
file a motion so I can, on your removal motion, file a motion.
I do not wish to continue or delay this any further. There's been no evidence presented to substantiate any kind of jurisdiction in this case. This is our second time. I've asked for this the first time. And there's been no evidence of any jurisdiction, and I don't understand why, you're insisting on, moving to another court date, and we have not addressed this very basic and fundamental issue of jurisdiction. If it cannot be proven and proven on the record, then this case must be dismissed. Well, I don't understand why we are delaying this any further.
We don't have to delay it any further. I can put a warrant out for your arrest. And you don't have to show up. You'll have to deal with that then. But at some point, I didn't say I was gonna put a warrant. I said if you're telling the court that you're not gonna come back to any court dates, then that's up to you. All I can do. What
I'm saying, sir, is I don't wish to delay this any further. There has been no proof of jurisdiction. There is no live injured party. There's a claim that the city of Detroit is an injured party, but I'm not aware of any international agreements or contracts that I've entered into with the city of Detroit, and the prosecutor can't provide that. And it seems like there's a bias going on here, because flat on his face, the prosecutor hasn't even spoken on this issue, and you just insist that we move to another court date, and I don't understand. Your oath of office is to uphold the Constitution. And what I'm asking is,
what you're saying in essence is that I don't have any authority. And you're failing. Read the Michigan court rules. Read your statutes. Read the Constitution over again, and you'll find that.
As I said before, I'm not asking you for legal advice or where
and
to go.
The Michigan Constitution.
You have, if you have a legitimate jurisdiction, I'm asking you. Is it a criminal jurisdiction under statutory law, or is it under the common law?
We're gonna give them
and you will not answer that question. Your Honor, we cannot proceed until I understand the nature and cause of the action against me.
I'm gonna say this one last time to you, sir. Go, and if you want to speak to the court, if you have any objection to the court and these dates, and if you don't feel that these dates are lawful, and if you, whatever your claim is that you're stating, you speak to the court through motions. I want that, and those motions that you're entertaining on the record right now, I've dismissed some of them already. I want you to file those motions with the court.
Under no basis
so that the court can read your motion and make a ruling and give the city attorney an opportunity to respond. If you do it the proper way, you might learn something. But I don't think that the way that you're going, that you're even if they show you documentation like it is in black and white, you're not going to believe that anyway. That's the perception that I'm getting from you. So I'm going to set these dates. It's going to be up to you whether you want to come to these court hearings or not. And if you don't come to the court hearings, the only recourse I have is to issue a warrant for failure to appear. Okay, so
sir, I still have this same question that you keep failing to answer, and without that question being understood,
and that's it. I'm done talking about it. Okay, that's it. So I'm going to set a
let the record show that the judge has refused.
Listen, sir, don't interrupt me again. Okay? Don't interrupt me again. Let's set a motion date for.
Do not consent. As I stated before, I'm trying to understand the jurisdiction of the court.
I'm not going to deal with it. You're going to jail.
Pursuant to
let's pull out the consent
Sixth Amendment.
Whatever work we need to do and fill it out, we're going to fill it out this time. I'm holding your client, well, Mr. Berry, you are, I guess, not representing this client because this client is probably, do you want the representation of a lawyer, sir, at this point now, sir? Because now you're looking at 30 days in the Wayne County Jail.
Please let the record show that I have attempted to understand the jurisdiction of this court, and this court has refused me that answer. And apparently it is a jurisdiction only understood to bar members and licensed attorneys. This is a direct violation of the Constitution, and I do not consent. I do not agree. That's it. Your Honor, I do not wish to be held in contempt.
It's too late.
I've merely asked a very basic, simple question, and you have refused to answer it. I feel as though the court is trying to constrain me to an unfair plea in absence of my understanding of the nature and cause of the action against me. Sir, did you receive the documents that I sent you asking for your anti-bribery statement? Hello.
I'm going to order you to report to the Wayne County Jail today.
You have told me this is a criminal jurisdiction.
Sir, please don't. I told you don't say. I'm going to add some more days if you keep on talking. You already got 30 days.
I don't understand, sir.
I'm adding more if you keep on talking. Please do not say anything else.
I'm sorry, Your Honor. It happened very fast.
It's happening again right now on the record. So those are the reasons
I'm just
that I
apologizing.
find, again, another contempt. And it just continues to happen. And I'm going to, now, if you have one more interruption with me, sir, I'm going to add another 30 days to that. And you're looking at 60 days. You're going to get 30 days. Right now, you're going to get 60 days if you have one more interruption to me. And it will be no early release. At this point, I'm going to order you to report to the Wayne County Jail. Sir, do you have any further questions?
I just want to make sure I can speak without being held in contempt or...
Yes, you may speak. I asked you, do you have any further questions, sir?
Thank you. Your Honor, I would just like to tell you, man to man, that it was not my intent to be in contempt. Has never been my goal. I try to do everything in accordance with the law. As you can see, I have filed documents. I've filed motions. I've requested information from the court, all in a desperate effort to wrap my head around the proceedings and what's going on here today. And I'm sorry if I may have gotten frustrated and not being able to understand the nature and cause and action against me. But just again, that was not my intention. I look forward to handling this as